Hello, everyone. Welcome to our Civic Awareness series for May. Again, my name is Will. I'm here representing the McCormick House. When Barb told me that we're going to have Professor Schwinn back to speak, I was pretty excited. I've been promoting this amongst my colleagues for several weeks. And we look forward to tonight's discussion. There's been some questions asking about Cantigny's status as we are able to, allow more people into the park. I am pleased to announce that we are doing just that. First Division Museum is still time tickets still reserved, but we are opening up quite a bit more capacity. Our concerts will start in June. So it's a great time of year to do this. The gardens look great. So stop by, check our website for special events that are coming up. But it's great to see everyone here tonight. And again, it's great to have Professor Schwinn back to talk about the Supreme Court. Colonel McCormick, I always try to come up with a story about Colonel McCormick and the subject that we're talking about every month. And my favorite Supreme Court story about Robert McCormick took place in 1931. It was something called Neer versus Minnesota. And it was a court case where there was a Minnesota newspaper that wasn't a well-respected newspaper, kind of a scandal sheet, if you will. But the local government tried to shut this guy down, its editor. And Mr. McCormick heard about it through his lawyer, Weymouth Kirkland, and fought the case all the way to the Supreme Court, and with a 5-4 decision, kept the paper open, and it served as a precedent in 1971, something called the Pentagon Papers during the Nixon administration. So Mr. McCormick obviously was very familiar with the Supreme Court, and he did successfully fight what he thought was a violation of freedom of the press. So that's my McCormick story, Barb, and I hand it over to you.
Thank you, Will. For all of you who may not be totally familiar with Zoom, I do want to make you aware of the view icon that's at the top right-hand corner of your screen. And when you click on that view icon, you're able to choose between gallery view or speaker view. And you might want to choose speaker view when Professor Schwinn starts to speak so that you can see him clearly and you're not looking at all the little boxes. Right now, I am totally stuck on my computer. Here a second. Right now, we are so fortunate and honored that Professor Steve Schwinn is joining us once again to discuss current issues before the United States Supreme Court, the judicial implications of packing the court that we have heard about in the news, and potential constitutional objections to federal voting laws currently being debated in Congress. Professor Schwinn teaches constitutional law at UIC John Marshall Law School and is a frequent commentator now on issues related to constitutional law on WTTW. His students admire him as evidenced by their comment that he is incredibly intelligent with a passion for teaching. Those of us who have attended his past presentations for the Civic Awareness series can attest he has the remarkable talent to make the complex understandable. Thank you so much, Steve, for joining us tonight.
Thank you so much, Barb, for having me back. I can't tell you how much I appreciate it. I'm going to drop a quick note here into chat with my email if anybody would like to follow up or have any questions. Let me see if I can get this going. There we go. It is such a delight and pleasure to see you all again. I can't tell you how happy it makes me to see your smiling faces. Hello, everyone. I am going to ask you a favor. If you are comfortable and if you have the bandwidth, I would really love to see your faces. And if you wouldn't mind unmuting your video, I really would like to see you. I do want to thank Barb and I want to thank Will for hosting me again and putting this event together. allowing us to come together, even if only by Zoom, to talk about the Supreme Court and goings-on at the court in Washington. I'm sad that we can't see each other in person and enjoy the beautiful facilities at Cantigny Park, but maybe next year. We'll see how that goes. So I do have some things that I'd like to talk to you about tonight about the Supreme Court this past term as we head into the final weeks of the term. Some important cases, trends, themes, and the like that we can talk about. I would invite you to drop notes into chat at any point if you have any questions or would like some clarification or comments, and we can unmute you and invite you to share your questions and comments with the group if you're comfortable doing that. And we will also try to reserve some time at the end for open discussion and Q&A. And of course, if there's anything that you would like to talk about or like to hear me talk about that I don't get to, please feel free to tell me, and I'll be happy to talk about it, assuming I know anything about it. So this was an extraordinary term at the Supreme Court in a lot of different ways. In one way, we saw Justice Amy Coney Barrett replace Justice Ruth Bader Ginsburg on the court, which now makes 3 Trump appointees on the court for a single-term president, rather extraordinary, and marks a sharp rightward shift, a sharp conservative shift on the Supreme Court. The conventional wisdom now is that the center of the court is with Justice Kavanaugh, whereas prior to Justice Amy Coney Barrett joining the court, the center of the court would have been with Chief Justice Roberts. And prior to that, it would have been with Justice Kennedy, and even before that, Justice Stevens. And so we're seeing a decades-long creep to the right on the Supreme Court and a sharp lurch to the right with Justice Amy Coney Barrett replacing Justice Ginsburg on the court. We don't know exactly what that's going to mean for the court yet, but I expect in the coming weeks we'll get a much better sense of what that means, and in the coming terms an even better sense of what that means. We can talk a little bit about her contributions so far, but quite frankly, we just don't have a lot of data points at this point. So I'm not sure that we can draw any firm conclusions other than she seems to be pulling the court sharply to the right. Because of her appointment in the waning days of the Trump administration, and Senate Majority Leader Mitch McConnell's priority of pushing her nomination through despite stalling a nomination in the last term of President Obama's administration, there is some pushback by Democrats and others to pack the court or take other action that would counterbalance the effects of Justice Amy Coney Barrett pulling the court to the political right. And so I just want to say a quick word about that. And if you have any questions or comments about it, we can talk about it a little bit more. I want to start here. Under our constitutional system, it's widely agreed that Congress has the authority to change the number of justices on the Supreme Court. Congress has some other authority with regard to the court's jurisdiction and the cases that the court hears. It has wide authority over the lower federal courts. And of course, the Senate confirms nominees by the president to the court as a check on the executive in our checks and balances system. And so Congress does have quite a bit of authority here, but Congress over time hasn't really exercised it very aggressively. Indeed, since the Civil War, we've had a 9-justice court. There was some change in the composition of the court in the early days of the Republic and around the time of the Civil War. And of course, we know about FDR's court packing plan, which never came to fruition, but nevertheless was on the table. And so we know that, that Congress has changed the composition of the court from time to time and has threatened to change the composition of the court from time to time. Just underscoring that Congress can do this. There are several proposals on sort of floating around out there. The most popular ones are things like simply adding appointees to the court to allow President Biden to counterbalance President Trump's appointees. That would be one proposal. Other more nuanced proposals include things like trying to politically balance the justices on the court. That's kind of a hard thing to do for a variety of different reasons, including the First Amendment and intrusions on justices' political associational rights. But nevertheless, that's one that we see out there, a kind of political balancing approach. We see an approach of expanding the court, but then having the court, rather than sit as a full court, sit in panels of 3 justices, for example, for any particular case. A number of other countries use that method in their constitutional courts and their Supreme Courts, and they do it with great efficacy and efficiency. And so there's some idea that we could do that here in the United States as well. And then there are proposals where we would expand the court, but then have justices rotating on and off the court and back into the lower courts in a way that would achieve a kind of political balance on the court. And there are a variety of different proposals along those lines, but one common proposal would be to have, for example, 10 permanent justices on the court that are politically balanced, and then 5 rotating justices on the court to make sure that there's a kind of circulating ideology on the court. The proposals are now with a commission that President Biden has created, and asked for recommendations for any court packing plan. Those of us who watch this kind of thing, I think, are thinking that anything that comes out of this commission will probably not get the votes in Congress and probably not move forward. But nevertheless, it does give us a kind of focal point for talking about the politics on the Supreme Court and thinking about some of the moves that the president, prior presidents and prior senates have made with Supreme Court justices. There is a question that came in on chat. Let me just address that before we move on and talk about a couple of other things that we're seeing at the court. The question to everybody is, do you think that the very threat of increasing the size of the court could have an influence on the court and on Justice Roberts in particular? This is an idea that Linda Greenhouse has expressed. I do think that's possible. And Linda Greenhouse, of course, is a longtime court observer. I have great respect for her and her ideas. I would caution about putting too much stock into that, though. We have seen Chief Justice Roberts, while he is commonly regarded as an institutionalist and somebody who's very concerned about the integrity and public confidence in the court, we've also seen him do make some pretty aggressive moves on the court in some of his rulings, one of which we'll talk about tonight, the Shelby County decision from 2012 that had an impact on the Voting Rights Act in a way that now is coming back to visit the court in a case this term. And so whether this kind of pushback could have a moderating effect on Chief Justice Roberts or even a Justice Kavanaugh, for example, I think there is some possibility that that could happen, but I don't want to put too much stock into that possibility. We've seen these justices move far to the right in certain cases, and I expect that this court is going to continue to move in that direction. There's a note here. Someone's kitchen work is on the noise side. I'm going to confess that actually might be my daughter making dinner in the background. So I think the noisy part of her dinner is now over, and I apologize for that. We should be moving into the quieter part of dinner, and I wish I could share the smell with y'all because it's fantastic. Too bad Zoom doesn't do smell. So we will keep that down. I apologize about that. And you might hear my dog at some point here too. Another thing going on at the court this term, which actually I think is really interesting, the court is hearing its cases telephonically, right? Not in person. And that really has changed the dynamics at oral arguments at the Supreme Court. And if you get a chance to listen to these on the court's website, I would highly encourage you to do it. The oral arguments are unusually well organized in that the justices each get a set amount of time to ask questions. They ask questions. When their time expires, we move on to the next justice. And all justices are participating pretty aggressively. So one of the things that we've learned from this telephonic sort of MO of the court these days is that Justice Thomas actually has a voice and asks really serious, good questions, which is something that we really have not seen Justice Thomas do when the court sits for live oral arguments. He's notoriously quiet at live oral arguments. So it's really exciting to get his views on these cases and hear his thoughtful questions on them. The trade-off for the organization is that we don't get the kind of give and take that we see in live oral arguments. And that's a real shame in my view, because we're not hearing justices react to each other and to the attorney in the way that we would in a live oral argument. And it makes predicting these cases much, much more difficult, and kind of unpacking and understanding what the justice's concerns are much more difficult. So while we do have some organization and focus in the oral arguments, we also, there's a trade-off, and we've lost some of the give and take and getting a kind of better sense of what the justices are really concerned about. There's a question that came in on chat. What about 18-year terms to try to limit the endless terms of old men and women? Yeah. Well, this is something, you know, one of the constitutional courts that I'm really familiar with in South Africa does limit terms for justices on the court. And the idea is to rotate members on the court, and members will often go back into private practice and private life after they've served on the court, making way for new members and new ideas and new thoughts on the Constitutional Court in South Africa. It keeps it dynamic, it keeps it balanced and exciting. It's a feature that we don't have in our own court. If we were to arrange something like that, the workaround that we would need is to accommodate the Constitution's Article 3's provision that judges get to serve for life. And what it would mean is that justices would have to rotate off the Supreme Court onto a lower federal court or some other equivalent, so that they basically would stay on the bench for life. And even that, I suspect, would be subject to judicial challenge. Given that the case would undoubtedly go to the Supreme Court, the challenge very might well win. So term limits for justices is a really interesting idea that other countries have used. I'm not sure how well it would work here, and I'm not positive it would pass constitutional muster. Justice Amy Coney Barrett, her participation in oral argument is, it's a little kind of hard to know exactly what her participation is going to ultimately look like. But so far, telephonically, she's asked very technical, very thoughtful, extremely probing questions that sometimes reveal her thoughts about the case, but more often just really press the attorneys on their positions. So again, when we go back live, we may get a better sense of where she's coming from on these cases through oral argument. So far, not so much, but we do get some really good and thoughtful questions from her in the oral arguments. So the telephonic hearings are one thing that we've seen at the court this term. Yet a third thing that we've seen at the court this term, which is, it's not totally unprecedented, but we've seen the court use this, this device a little more in the recent terms than we have seen historically. And that is what we call the court's shadow docket. The court's shadow docket involves cases that come to the court on an emergency basis, where a lower court has either granted or denied injunctive relief, and the losing party asks the Supreme Court to intervene on an emergency basis to either grant or deny the injunctive relief that the lower court has ordered one way or the other. And we've seen the Supreme Court this past term, really going back to last summer, play a really aggressive role with its shadow docket, and in particular in two areas. The first area is with regard to state restrictions based on COVID, state health and safety restrictions based on COVID, and how those restrictions, principally how those restrictions interact with religious freedom. The second area where we've seen the court intervene on its shadow docket, and this occurred primarily in July, August, September, even into October last year, was with state election law and changes that states were making to accommodate the COVID pandemic and allow voters to vote safely given the COVID crisis. Many of these cases were going to the court. With regard to religion, we'll talk a little bit about this later in the session tonight, but I think the court's rulings on its shadow docket with regard to religious claims against state restrictions based on COVID, I think those rulings actually foretell the direction that the court is going with its religious jurisprudence. And spoiler alert, where I think that's going is to radically enhance free religious practice and radically constrict the Establishment Clause. And with regard to election law, I think too, the court's rulings foretell where it's going with its jurisprudence on election laws. And as we'll discuss here in a moment, I think where that's going is to radically restrict voting rights and elections, and at least compared to where we have been, and to allow states more freely to enact restrictions on voting rights and to gerrymander electoral districts and to engage in other electoral practices that are more and more commonly regarded as having bad impacts on our democracy. So I do want to talk about the cases, some of the cases that we that I think are really important, starting with a voting rights case. But let me make sure I get to questions in the chat. So Rebecca asks everybody, if Democrats were able to put more justices on the court to packet, couldn't Republicans do the same next time they won the presidency? This sounds like an infinite back and forth leading to an ever-expanding Supreme Court. Rebecca, I think you put your finger exactly on it. I mean, this is the worry. If one party does it, won't the other party do the same thing when the other party gains power? And we've seen this kind of back and forth with regard to the filibuster on judicial nominations, right? Where we used to have a Senate filibuster on judicial nominations. One party decided first we're going to take away the filibuster for lower court nominations. The other party said, well, we're going to take it away for Supreme Court nominations. And all of a sudden there's no more filibuster for judicial nominations, and they've become dramatically more politicized since that kind of race to the bottom between the two parties. The lesson learned, or I think the lesson that they ought to have learned, I think is exactly what Rebecca's asking about and suggesting, and that is, if one party does it, you can bet that the other party will, and maybe even more aggressively when the other party gains power. The Democrats' answer to that today, I think, is that the Republicans have been much better at doing this, much more effective at doing this, and have really managed to stack the federal courts, particularly during the Trump administration, with young, extremely conservative jurists across the judiciary, not only at the Supreme Court, but in the lower federal courts as well. And there's some urgency among the Democrats to kind of counterbalance that. And so we'll see what comes out of this commission that is reporting to President Biden and what the Democrats ultimately do with this. I mentioned the filibuster a second ago. Unless the Democrats are able to figure out a way to work around the filibuster and even to get their entire caucus together in the Senate, remember they only have 50 in the Senate, so they can only squeak by. They won't be able to pass a court packing plan, even if the House were to pass a court packing plan. Joe Manchin, a Democrat from West Virginia, has already signaled that he's not in favor of court packing. There's some other Democrats that have similarly expressed some caution about that. And so it's not even clear that the Democrats could get their caucus together to do any court packing plan, even if it were to pass the House. So we'll see what happens with that. I think Rebecca's comment is extremely insightful. Tricia's comment as well, and the earlier comment that the mere threat of increasing the size could have an influence on the court. That's exactly what we saw with Roosevelt's court packing plan, the famous switch in time that saved 9, with Justice Owen Roberts' switch in 1937. Who knows? We could see a similar effect with this court. I'm not banking on it myself, but we could see an effect. I think what I'm going to do is just pause here for a second and give you a chance to put any other questions that you might have in chat before we talk and a really big case at the Supreme Court that I want to try to put into a broader context for you. So I'm just going to pause for a second. If you have questions, feel free to ask them.
Steve, I did get a question by email that might be appropriate for now, and I'm not sure that you would know the answer to this, but there's a concern of how many decades do you believe the Supreme Court set back the course of criminal justice with its recent ruling that it was okay to sentence youth to life without parole?
Oh. That's a fantastic question. And I think this is an area that we need to keep our eye on. Youth sentencing, life without parole for youth sentencing, and the Supreme Court's ruling on that issue is a huge, breathtaking setback. And this is a mark of how the court has moved since Justice Kennedy left the court. Justice Kennedy, of course, was famous for writing these opinions about sentencing with regard to youth, with regard to adults with mental disabilities, and the death penalty. And his departure from the court and replacement with Justice Kavanaugh and Amy Coney Barrett replacing Justice Ruth Bader Ginsburg is dramatic in this area. It's a really significant setback. Related to this, the Supreme Court in the last couple of decades has been no friend to opponents of the death penalty. I think that the court, to the extent that the court is going to hear any more death penalty cases, I don't expect this court will be any more friendly to opponents of the death penalty. Stated positively, I think that this court is going to throw its full weight behind the death penalty, and I don't think that we're going to see that go away anytime soon. So too, life without parole for all offenders, but here we're particularly talking about children. I think that that's something that is not going to change anytime in the near future. That's a fantastic question, and it is a real big setback. On the other side of the criminal justice docket, I'll just mention here because the question came up. You know, the Fourth Amendment cases produce sort of famously surprising alliances on the court. We often see some of the court's most conservative jurists align with some of the court's most progressive around ideas about really sort of freedom from search and seizure under the Fourth Amendment in a sort of libertarian kind of spirit. And we're starting to see a little bit of that so far, even already with this more conservative court, where the court ruled this term, for example, that officers shooting a person constitutes a seizure for Fourth Amendment purposes. It turned out that that wasn't obvious going into the case, but the Supreme Court ruled that way this term. And so while we may see some movement to the political right in terms of things like sentencing, we may see, we actually may see some moves by the court in a kind of libertarian direction under the Fourth Amendment. A couple of questions came in. Let me make sure that I'm staying on top of these.
One question is, if the Supreme Court supports the death penalty, what happens in states that have already outlawed it?
So states can outlaw it. There's no requirement that any state impose the death penalty. And the federal government can even put a moratorium on the death penalty, which it more or less had prior to the last few months of the Trump administration. And that's perfectly fine. But where the death penalty jurisprudence is becoming really interesting is with regard to lethal injection and states' access to the medications that they need to conduct lethal injections. Opponents of the death penalty have done a fantastic job of persuading drug manufacturers that they should not provide their drugs to states that administer the death penalty. And as a result, states have had a real hard time getting their hands on key drugs that they need to administer lethal injection. And so states are now looking to other alternatives for the death penalty. And you may have read recently, for example, some states are looking to alternatives like a firing line, and even death by hanging. Some states going back to execution chambers, gas chambers, and electric chairs, and away from lethal injection because the drugs are drying up. And so while opponents have done a very effective job of getting the market for these drugs to dry up and having states have a real hard time get their hands on them, on the one hand, it's produced this sort of backlash effect where states are now looking to even more draconian ways to administer their death penalties. And I suspect that the court's going to uphold all of that. And if anything, the court has been, and I expect will continue to be, highly critical of death penalties opponents' efforts to make it difficult for states to get their hands on these drugs. Marianne asks, this goes in a slightly different direction. It almost sounds like there's no hope for passage of SR1. What can we do? We'll talk about that in a second. And I'm not so sure. There may be portions of federal voting rights that can pass, and possibly even in a bipartisan way. We'll just have to see how the politics of this shake out. I think some of the things that have happened as recently as yesterday, for example, with Congresswoman Cheney, I think are going to influence the politics, and at least in the House moving forward, maybe the Senate as well, in ways that I think are difficult to predict right now. And so I don't know whether there's any negotiation room in SR1, but we'll talk a little bit more about that in a second and the significance of that. Jennifer asked everybody, what about the effort to encourage a retirement to put a Black woman on the court? Yeah, so there is a move to encourage Justice Breyer to retire, right, and to allow President Biden to put a nominee on the court before the midterms, when Republicans could potentially retake the Senate and obstruct anything that the president wanted to do in that regard. I really, truly just have no idea how that's going to play out. Justice Breyer is getting up there in years, but he is just whip smart. The man is a workhorse, and I don't think would be anywhere near retirement if left to his own devices, but he's as aware of the politics as anybody is, and as aware of what happened with Justice Ruth Bader Ginsburg, and so he very well might be persuaded. We'll see. By the way, a number of folks have said he hasn't announced his retirement yet, and that doesn't bode well for a summer retirement. That's not quite right. Justices often will not announce a retirement until the formal close of the session, which won't come for at least another couple of weeks. And so the next few weeks into June are going to be critical to watch for a potential Breyer retirement. The next most senior justice who is likely to retire would be Justice Thomas. But I don't expect that Justice Thomas would announce a retirement during a Biden administration. I think he'll try to hold on. Cheryl asks, if the Supreme Court supports the death penalty, what happens in states that have already outlawed it? Yeah, and so states can continue to outlaw it. There's no requirement that they impose a death penalty. But for states that do have a death penalty where condemned prisoners challenge it as unconstitutional, I think the Supreme Court's going to rebuff those challenges. I just don't see that there's a lot of room to work in that area with this Supreme Court. We're going to have to death penalty opponents are going to have to do a lot of work to get a court that will rule the death penalty unconstitutional. Okay, let's talk a little bit about voting rights. There's a really interesting and important case on the court's docket this term that in and of itself hasn't garnered a lot of attention. But given the larger context of voting rights, including what's going on at the federal level, including the imminent redistricting based on the 2020 census, and states now thinking ahead to voting restrictions and how they're going to allow voters to vote in the midterm elections, and so much on the line with the midterm elections, at least at the federal level. There's just a lot of stuff going on here. And so what I want to do is try to put this case into the larger context to think about voting rights and state and federal election laws as we're moving forward and looking to the midterm elections in 2022, where, you know, if history is any guide, Republicans stand a good chance of retaking the House and a chance of retaking the Senate, which would be a headache for President Biden in terms of his policy agenda, but also in terms of judicial appointments and trying to do anything at the Supreme Court or the lower courts. And so I think these are all really important to keep our eye on. The case that I'm thinking about is called Brnovich versus Democratic National Committee. And this is a case that comes out of Arizona. Arizona has two laws that are at issue in this case. One law is called the out of precinct law. The other law is called the Ballot Collection Law. Let's start with the out of precinct law. What the out of precinct law says is that for jurisdictions in Arizona that have a location where you vote, a sort of voting location, and that's most of the jurisdictions in Arizona, the out of precinct law is a state law that says if a person does not vote in their correct precinct, their ballot shall be discarded. Now, that's pretty dramatic because what it means is if a person voted in the wrong precinct, their ballot is discarded as to the candidates that they were not qualified to vote for, but also with regard to the candidates that they were qualified to vote for. So for example, statewide offices or congressional seats that are still within their district or still within the precinct, but the wrong precinct. And so this is a really dramatic law. And means that if a voter happens into the wrong precinct, they will not have their ballot counted. When we overlay that with the fact that in Arizona, and particularly in communities of color in Arizona, precinct locations change pretty regularly, and finding the correct precinct actually turns out to be pretty challenging for many voters, what we have is a real issue. With regard to disenfranchising voters, particularly voters of color. The other law, the ballot collection law, limits and in some cases prohibits people from collecting ballots and then delivering them en masse. Sometimes we hear this called ballot harvesting, where, for example, you take a friend's ballot or maybe even a group of friends' ballots or a group of family members' ballots and drop them off in a voting drop box, for example, because those people either can't go or it's inconvenient for them to go or they don't have transportation or they can't leave their home for any reason, for a variety of reasons. And this too turns out to have a disparate impact on communities of color in Arizona, where Black and brown voters are disproportionately disenfranchised by this, this ballot collection restriction, because it's communities of color where we predominantly see ballot collection practices. The state legislature knew that when it went into adopting these laws. And so challengers to the law are arguing that the law violates Section 2 of the Voting Rights Act, which we'll talk a little bit more about here, and I'll put in larger context for you for a second. But that it violates Section 2 of the Voting Rights Act for two reasons. Because the practices are intended to discriminate in the vote by race, and because they have the effect of discriminating by race in the vote. And we'll take a look at each one of those in turn, but before we do that, I kind of want to telescope out and give you a broader sense of the Voting Rights Act and where Section 2 sits and why this particular case is so critical at this moment. Before I do that, I'm just going to make sure that I'm up to date on the questions. I saw one came in. Cheryl asked to everybody, I've been an election judge, and in my experience, a person trying to vote in the wrong precinct would be declared ineligible or refused ballot. How is it possible to vote in the wrong precinct? Right, great question, Cheryl. And so typically what would happen, at least in Arizona before the law, is that voters who voted in the wrong precinct would have their ballot counted provisionally. What that means is the election judges would collect the ballot and hold on to it until they could verify that the voter was a registered voter and should have voted in a different precinct. Sometimes that requires the voter going into the voting office, the Secretary of State's office, and showing proof that they were a voter and that they simply made a mistake, and then their vote would be counted. Other times it just requires the election judges to verify that the voter was indeed registered but just mistakenly voted in the wrong precinct, and then they can count the ballot. Of course, if they can't verify that, then the ballot would be discarded. But the Arizona law says that all ballots, categorically, whether they could theoretically be validated or not, all ballots in the wrong precinct are going to be discarded. And provisional ballots are also accepted in California, a direct message or ads. Yes, that's exactly right. How do they even get a ballot? I have to give my name when I go to vote, and they look me up in the registry, right? And so these would be voters who are who perhaps got a ballot, for example, in the mail and are bringing it in, or have somehow perhaps early voting. But Joanne, you're exactly right. That's my experience at my polling location as well. In some places in Arizona, it works differently so that somebody could physically vote at the wrong precinct or put their ballot in the wrong drop box in early voting or on election day. And if they were to do that, the ballot would be categorically discarded. So Section 2 of the Voting Rights Act, let's riff on that for a second. And what I want to do is talk about the 1965 Voting Rights Act and the two key provisions of it, and kind of why Section 2 today is so important. So if we go back to 1965, when Congress enacted the Voting Rights Act, there were two key provisions. One provision is what we've been talking about, that's Section 2 of the Voting Rights Act. Section 2 of the Voting Rights Act prohibits any action by a state that would discriminate by race in the vote, okay? And after an amendment in 1982, Section 2 of the Voting Rights Act prohibits any action by a state that intentionally discriminates by race or that has a disparate impact by race with regard to the vote. So two different ways to show a Section 2 violation: a discriminatory intent or a discriminatory impact. And you might remember a few minutes ago I said that the challengers to these laws in Arizona were raising both kinds of claims, that the state legislature intentionally discriminated by race, but that it also, these practices also had a disparate impact by race. So Section 2 allows people who are disenfranchised or might be disenfranchised to bring an individual lawsuit against state authorities for race discrimination in the vote, either intentional race discrimination or discriminatory effect. When Congress enacted the Voting Rights Act, it understood that Section 2 litigation would be helpful, but that it wouldn't, it wasn't a sort of comprehensive remedy to many of the voting practices that we see. And part of the reason why is because while individuals could sue under Section 2 of the Voting Rights Act, they're unlikely to be able to stop the offending electoral process before the election itself. And that's just because litigation takes time, right? And so, you know, you can't sort of undo the election and have a do-over. You can't put that toothpaste back in the tube. And so Congress understood in 1965, when it enacted the Voting Rights Act, that it needed, in addition to this sort of prospective litigation approach, it also needed a kind of prophylactic approach, a kind of Band-Aid approach to state election problems. And that's the second key provision in the Voting Rights Act of 1965. It's Section 5. It's called preclearance. Section 5 preclearance says that certain states and jurisdictions that have a particularly ugly history of racial discrimination in the vote, that those jurisdictions will have to get approval from the US Department of Justice or from a 3-judge panel, a federal panel in Washington, D.C., before they can make any changes to their voting laws. And the reason why is because Congress understood in 1965 that these jurisdictions used really sort of creative and clever ways to disenfranchise people, principally Black and brown people, by race, using racially neutral means, right? And so there were a lot of different devices that states and local governments were using that looked on the face of them racially neutral, but nevertheless had this racially disparate impact. And if they had to get federal approval before they adopted them, that would give the federal government a chance to stop those practices before they even started. Now, when the Justice Department or this 3-judge panel evaluates these practices, what they ask is whether the voting practices would have a retrogressive effect on voting rights of individuals of color. What that means is, as compared to the status quo ante before the voting practice was adopted, would the voting practice mean that less people of color had the opportunity to cast a free and fair ballot? If they would, then the voting practice would be denied and the state would never be able to enact it. If the state, on the other hand, could show that it was not retrogressive, then the Department of Justice or the 3-judge panel would go ahead and approve it. So these two key provisions needed to operate sort of in a kind of complementary symbiotic way, right, in order to prevent states from engaging in voting practices that would disenfranchise people because of their race. Well, opponents of preclearance in Section 5 have long litigated preclearance and challenged Congress's authority to enact preclearance in the courts. In 2012, they won. The Supreme Court in 2012, in a case called Shelby County, this is the case that I referred to earlier when we were talking about Chief Justice Roberts sometimes taking an extremely conservative stance on issues. The court in Shelby County said that Congress didn't identify offending jurisdictions precisely enough in order to enact preclearance to affect those jurisdictions. Effectively, what this did was to lift the preclearance requirement for those jurisdictions. And the day after the Supreme Court ruled in the Shelby County case, many of those covered jurisdictions, literally the day after the Supreme Court ruled, enacted laws that the Department of Justice had previously declined to preclear because they had this racially retrogressive effect on voters of color. So states like North Carolina, Texas, Alabama, Georgia, other covered jurisdictions enacted these laws and were able to put these laws on the books then that had this racially retrogressive effect. And to this day, Congress has not gone back and changed pre-clearance in a way that would satisfy the Supreme Court under that Shelby County ruling. What this means now is that the portion of the Voting Rights Act that's doing all the work is Section 2. Section 2 is everything today. And so the litigation in the Brnovich case is extremely important because it will determine the future of Section 2 of the Voting Rights Act. And remember, those jurisdictions that were previously covered under Section 5 preclearance have gone ahead and enacted all kinds of laws that the Justice Department and federal courts have determined would have a retrogressive effect on people of color's ability to vote. And so these laws are already on the books. And moreover, we've seen in the wake of the 2020 presidential election and former President Trump's, sort of continual thumping on the integrity of the election, we've seen a number of states, Georgia, Florida, Texas being the key states, but we've actually seen 48 states consider legislation that restricts the right to vote in the name of voting integrity. There are over 400 bills nationwide in 48 states that restrict the right to vote in one way or another right now, pending in state legislatures. Some, as we know, have already passed, that are going to be subject to Section 2 litigation under the Voting Rights Act. And again, what the court says about Section 2 in the Brnovich case will really foretell the results in all of those challenges. And so we're seeing a number of states, for example, adopt laws that restrict early voting, that restrict absentee voting, that restrict drop boxes for voting, that restrict the days of early voting and the places of voting, that require voter ID and make more stringent voter ID requirements. And, some laws that we've seen, for example, in Georgia and Florida, restricts people's ability to deliver water and food to people who are waiting in long voting lines. I mean, these laws really are all over the place. And I think ought to deeply concern us. Again, state legislatures are enacting these laws for the putative reason of protecting the integrity of the polls in reaction to the claimed the claimed problems in the 2020 election, which there really isn't substantial evidence of. And they're having the effect of restricting the right to vote, principally for communities of color. If the Supreme Court in the Brnovich case reads a restrictive Section 2 of the Voting Rights Act, what that means is that opponents of these laws are going to have all the much harder time challenging these laws in the federal courts under Section 2. And with Section 5 preclearance effectively wiped off the books at this point, we can't rely on Section 5 preclearance as a device to protect against these laws. All this means that there's a kind of perfect storm going into the midterm elections in 2022 that is that's going to have a disparate effect on voters of color and in general on the right to vote. The other thing going on, of course, is redistricting, right? States are now going to start redistricting in response to the 2020 census, and we expect that states are going to be as aggressive as they've ever been in terms of political gerrymandering. And that too is likely to have a disparate impact on communities of color, particularly in locations where they're gerrymandering, where jurisdictions that might previously have been covered by preclearance and required to go through preclearance for their gerrymandering. A number of questions have come in. I'm going to address these before we talk a little bit about what's happening at the federal level. So there was a question, example of this, and I'm not sure I have the context for that. I wonder if the author could remind me. I'm most interested in hearing about the cases over threats to our First and Second Amendment rights. Okay, good. We can talk a little bit about that. I'm interested in hearing about threats to religion. Yep, good. In cases as hiring and where groups wants LGBTQ rights ranked more higher. Okay, good, good, good. We can loop around and talk about some of those cases. It's shocking that 48 states are considering laws to restrict voting rights. I know the arguments of the right, but what are left-leaning states arguing? Okay, good. So in response to Cheryl's question, many of these laws are thankfully going nowhere. And so in progressive states that are dominated by Democrats who by and large are seeking to expand the franchise, not restrict it, we do see litigation introduced, but it's almost certain to fail. And so in our state, for example, in Illinois, there's legislation pending that would restrict the right to vote, but we don't expect that it will actually pass a Democratic legislature and be signed by Governor Pritzker. And that's the same situation that we see in many states. Example of a retrogressive impact. Okay, good. So an example of a retrogressive impact, let's take a look at what the plaintiffs are arguing in the Brnovich case itself. So here, take the out of precinct policy. When election officials discard categorically ballots that are cast in precincts that are the wrong precincts, the opponents of that law argue that it has a disparate impact on communities of color, because as it turns out in Arizona, in communities of color, but less so in white communities, polling places change all the time. And it turns out to be really, really confusing to figure out where you're supposed to vote if you're a person of color in many places in Arizona. Whereas we just don't see those kinds of changes in predominantly white communities in Arizona. And it's that kind of disparate impact that under Section 5 preclearance would also be a retrogressive impact on voting rights of racial minorities. And we see a similar kind of impact with the ballot collection. What's going on here in Arizona, again, this is all very fact specific about what's going on in Arizona. In Arizona, communities of color rely on ballot collection far more frequently than white communities do. And so we can show with numbers that a ballot collection restriction has a disparate impact on communities of color in a way that it doesn't disparately impact white communities. And that too could be a retrogressive effect or impact if these laws would be subject to preclearance under the Voting Rights Act. Rebecca asks, how do voter ID laws disenfranchise non-white voters? It's a fantastic question. And again, this is all very fact specific. So what challengers to voter ID laws have argued is that the way a particular voter ID law operates, right, that the particular voter ID law has a disparate impact by race because people of color are less likely to have voter ID that is accepted by state authorities than people who are in predominantly white communities. And this all depends on how the voter ID law operates. More and more what we're seeing, quite thankfully, with voter ID laws is that states that require voter ID laws are expanding the IDs that they're allowing and allowing voters to vote provisionally if they can't produce a valid voter ID at their polling location. So they get to cast their ballot, but then later have to go to the Secretary of State's office to show that they really are who they say they are with their acceptable voter ID. But in some states, what we're seeing is just the opposite. So for example, Texas is famously restricting its voter ID laws and valid voter IDs in a way that is obviously politically calculated. So for example, in Texas, a voter ID, a voter could use a gun license for voter ID, but a voter couldn't use a public school student identity card for voter ID. And it's that kind of components to voter ID laws worry about. These cases are can be very hard to prove, disparate impact based on voter ID, because they are so fact specific. And again, more and more states are thankfully giving accommodation and exceptions to individuals who can't produce voter ID. But still, in some states, we do see some disparate racial impact. So what the court has to say about Section 2 is going to be incredibly important in the Brnovich case. And there's some indication that the court could tighten up Section 2 in a way that would make Section 2 litigation and Section 2 challenges much, much more difficult. If it does that, that's going to allow and invite states to continue their trend in restricting voting rights because they know they can do it with impunity, without being subject to Section 2 litigation, and with Section 5 effectively off the books. They can do it without preclearance as well. And that could have serious impact on the midterm 2022 elections. All of this applies with equal force to political gerrymandering. So to the extent that states are engaged in political gerrymandering, which in many locations serves as a proxy for racial gerrymandering, the same effects are going to be in place. Challengers to political gerrymandering that has racially disparate impacts are likely to be hamstrung in their ability to bring Section 2 cases under the Voting Rights Act, even though those gerrymanders never would have passed muster under Section 5 preclearance. And so with all of this going on, Congress is now starting to consider some very serious and aggressive solutions at the federal level. So one of these we had mentioned earlier, the For the People Act, which is a comprehensive federal voting rights act that is quite possibly as aggressive as anything that we've seen since the Voting Rights Act of 1965. It includes everything from making voting registration easier to making voting itself easier, to changes and innovations with regard to campaign finance, disclosure requirements in campaign finance, public financing schemes for U.S. House members, and rejiggering the presidential public financing scheme. Restrictions on redistricting to require states to use independent redistricting commissions when they start to redistrict after the 2020 census, and election security measures that that will help ensure the integrity of the polls, including requiring states to use paper ballots and paper backups, providing states with a ton of federal resources to secure their ballot boxes and their voting machines, and to make voting the voting machinery a critical a critical mechanism for the state, so that they have to use enhanced techniques under other federal laws to secure the ballots and the votes. There was a question earlier about how likely this is to pass. I think it's probably unlikely to pass in its full form, but I do think that it could be subject to some negotiation, and there may be pieces of it that could pass, perhaps even in a bipartisan way. Given the filibuster rule in the Senate, unless Senate Democrats were able to come together entirely as a caucus and hang together for the act, and unless they were able to either do away with the filibuster entirely or use a different device that they have used to pass some of the COVID relief packages, that it's unlikely to pass the Senate, and so even if it could pass the House, there is going to need to be a kind of confluence of a number of unlikely events in the Senate for it to pass the Senate. A question came in, Rebecca asks, wouldn't this Federal Voting Rights Act violate federalism and lead to even more loss of respect for the integrity of the election results? That's a great question, Rebecca, and you're right on. Opponents of the act and many measures in the act are citing federalism and lack of congressional authority to do exactly what Congress is trying to do here. What Democrats argue back is that Congress has a lot of authority under the 14th Amendment, which bans racial discrimination in voting, under the 15th Amendment, which also bans racial discrimination in voting, under the Republican Form of Government Clause, which allows Congress to enact laws that ensure states have a Republican form of government, and under the Elections Clause. The Elections Clause itself gives most election authority to the states, it's true, but that also says that Congress can provide for elections for federal elections whenever it wants to. Now, we have a tradition in our country where Congress has not been very aggressive in doing that, but Congress surely could. And if it would, what that would mean is that then Congress could prescribe rules for federal elections, which then in effect would be for state elections as well, because we run these elections together as a single election. And so if Congress were to step in through this act and require electoral changes, I do expect that they'd be challenged in the courts. And some of the challenges might well be successful given the direction of the Supreme Court on voting rights. But many of these are well within congressional authority under the 14th, 15th Amendments, the Republican Form of Government Clause, and the Elections Clause itself. And then Cheryl asks about the John Lewis Voting Rights Act. So this is the other piece to the puzzle. The John Lewis Voting Rights Act is an act that's been kind of kicking around Congress now ever since the Shelby County decision came down in 2012. Remember, the Shelby County decision effectively eviscerated the redistricting provision, Section 5 of the Voting Rights Act. Technically, what the Shelby County decision did was to say that Congress didn't draw precisely enough what the jurisdictions are that will be covered under the preclearance requirement. The John Lewis Voting Rights Act does just that. It identifies jurisdictions that should be subject to preclearance with greater precision and more relevance given today's politics and today's voting practices in these jurisdictions, and therefore much more likely to pass muster at the Supreme Court. What do I think the likelihood of that passing is? I think it's unlikely. I think it's somewhat less likely even than portions or all of the For the People Act, and the reason is a political reason. You know, we're just so sharply divided these days, and members of the House and Senate are not going to want to vote for a bill that subjects their own state to what they see as an onerous and federalism violating preclearance provision. And if we can't count on members from those states voting in favor of the John Lewis Act, I just don't think we can count on it passing. So unless there's an even more unusual confluence of things to happen with the John Lewis Act, I think that's even less likely to pass than the For the People Act. But again, you know, with Democrats in control of both houses at this point and President Biden in the White House, I think the politics are as strong as they've been since President Obama's first term for these things to happen. And so, you know, we'll see whether the White House can negotiate with Congress and maybe even bring some Republicans on board for some or all of this legislation. I've got an eye on time, Barb, and I want to make sure that we have some time for open discussion. I think if it's okay, I think I'd like to say a word about a religion case that's on the court's docket this term that dovetails nicely with a question that came up about First Amendment and touches on religion, but even I think gives us a nice segue to talk about some of the speech issues that came up in the questioner's comments. This is the Fulton versus City of Philadelphia case. The court heard oral arguments in the fall. It's a really interesting case where the City of Philadelphia, as it turns out, like many locations, contracts out its adoption services. So the city itself sort of supervises and runs a portion of its adoption services, but it also contracts out a good portion of those services to the private sector, in particular nonprofit social service organizations that are skilled at placing foster children in foster families. One of these organizations is Catholic Social Services. Catholic Social Services is exactly what it sounds like, a nonprofit social services agency that has a religious bent, a Catholic bent in particular. The City of Philadelphia had a rule that its contractors in the foster care system couldn't discriminate by sexual orientation. And what that meant is that all nonprofits who were contracting with the city had to treat foster children and foster parents the same, whatever their sexual orientation was. Well, this didn't sit well at all with Catholic Social Services. Catholic Social Services didn't want to place children or recommend the placement of children with gay and lesbian parents. And so Catholic Social Services said, look, we won't do this ourselves, but we will refer these placements to other nonprofits who would make the placement. So they had a kind of workaround. The city didn't like its workaround, and so the city terminated the contract. Now that was pretty dramatic because Catholic Social Services had been providing these services to the city of Philadelphia for as long as anybody can remember, and had millions of dollars in city funds that they had administered in recommending placements of foster care children with foster families in Philadelphia. And so terminating the contract was actually a really dramatic measure. And by all accounts, except for their discrimination by sexual orientation, by all accounts, Catholic Social Services was doing a wonderful job in the foster care system. Again, with that significant caveat that they wouldn't place children with gay and lesbian parents. So Catholic Social Services sued. And they said that the city's policy of requiring non-discrimination, the city's non-discriminatory policy, interfered with their religious freedom. What they said was the city, by requiring us not to discriminate by sexual orientation, is violating our free exercise right to discriminate by sexual orientation in a way that our religion compels us to do. The case worked its way all the way up to the Supreme Court. And again, the court heard oral arguments in the fall. This is a case that's really important, not because it deals with foster care in Philadelphia. That's too important to be sure, but because there could be a sea change in the way the Supreme Court deals with free exercise challenges. In particular, the court, under a doctrine now that's several decades old, when the court assesses a challenge against a religiously neutral law, because that law has an incidental effect on religion, the court almost always upholds the law under a test that we call rational basis review. What the court says is the law is rationally related to some government objective, and therefore we're going to uphold it. On some level, this kind of makes sense, right? Because if it were otherwise, religions could effectively write exceptions to whatever law they wanted to, if a law violated their religious beliefs or tenets. And given how easy it is to establish a religious belief or tenet with the Supreme Court, we could imagine that religions of all different varieties could basically shoot holes in all of our laws across the board. Well, that doctrine has been controversial since it came down in 1990 in a case called Employment Division versus Smith. And this case, the City of Philadelphia case, actually tests that doctrine. The challengers in the case, Catholic Social Services, they're asking the court to apply a different test to free exercise challenges against religiously neutral laws. What they're asking the court to do is apply the exact opposite constitutional test. It's a test called strict scrutiny, which would mean that if a religiously neutral law interfered with a religious practice, even incidentally, there's no intent to interfere with a religious practice, it just sort of incidentally affects a religious practice. In cases like that, the religion would effectively get an exception to the law. There's good reason to think that the Supreme Court is moving in that direction. Again, I go back to the court's shadow docket with regard to COVID restrictions over the summer and into the fall, and some of the court's rulings on free exercise and the Establishment Clause in recent terms suggest that the court is moving to greater religious liberty and freedom under the Free Exercise Clause, while at the same time a much more constrained reading of the Establishment Clause and allowing government to more freely engage in establishment of religion. And given those two trends kind of operating on parallel tracks, what I expect the court to do in this case is to actually mark a sea change in free exercise jurisprudence, which will be a really big deal, not only for what's going on in Philadelphia, but across the board with regard to religious liberties. Now, the questioner had earlier asked about what about non-discriminatory laws against religious employers who want to discriminate based on their religion, right? A non-discriminatory law that says employers cannot discriminate by sexual orientation, for example. Can we apply that to an employer who is a religious employer and sees it as part of their religion to discriminate by sexual orientation? Well, I think that's where we're headed next with this jurisprudence. And if the court goes in the direction that I expect it will in the city of Philadelphia case, then I expect the next step for the court to be to start to overturn some anti-discrimination laws as they apply to religious employers. Now, where this kind of gets interesting is that, you know, in our country's history, it turns out not to have been that long ago that employers and a variety of people objected to non-discrimination laws by race on religious grounds. What they were saying is that when the government prohibits me from discriminating by race, that violates my deeply held religious conviction and therefore violates my free exercise rights. The sort of 2021 version of that is discrimination by sexual orientation or sexual identity, and religious employers saying we need a religious exemption in order to do that. The reason that I mention this is because it's not an easy case, right? It's not an easy case at all. The Supreme Court is on this kind of track toward moving to greater religious freedom, greater religious expression, less government interference with religious practices on the one hand, but on the other hand, the justices on the court are as aware as we all are that this idea of religious exemption from anti-discrimination law has a pretty ugly history in our country's not so distant past. And so the court's got to be acutely aware of how that's going to play, you know, in another 50, 70 years from now, if the court were to rule in favor of religious employers, for example, as against members of the LGBTQ community. So the City of Philly case is an extremely important one for religious reasons, also for LGBTQ rights, and the direction for the court in both of those areas. Essentially, so Diane says, essentially allowing religions to discriminate, slippery slope, back to the dark ages we go. Yeah, maybe. This turns out to be kind of interesting too. There are state and federal laws that are called Religious Freedom Restoration Acts that operate both at the federal level and at the state level. At the states, we call these mini RFRAs, RFRAs, Religious Freedom Restoration Acts. that actually do exactly what Catholic Social Services is asking the court to do under the Free Exercise Clause in the City of Philadelphia case. That is, to apply strict scrutiny when the government has a religiously neutral rule that has an incidental effect on a religious practice. These laws have been around since the early 1990s and have been in effect. One that we might know about, in fact, Barb, you can remind me, we might have talked about this, was the contraception mandate in the Affordable Care Act as it applied to Hobby Lobby. Hobby Lobby sought an exemption under the federal Religious Freedom Restoration Act to get around the contraception mandate for its employers in the Affordable Care Act, and it succeeded. So these laws, we've got almost a 30-year history with laws like this, and certainly they have produced some issues for us, but they haven't resulted in a total kind of religious exception for every law that we might expect. And so the evidence on this is you know, not too bad, and we haven't quite gone back to the dark ages, but there is great worry that we could. Marianne asks, is there any recourse to a decision by the Supreme Court? Can their decision ever be reversed, and how? Well, so for constitutional rulings, the answer is no, unless we amend the Constitution or change the composition of the court. For statutory opinions, like the Brnovich case, Section 2 of the Voting Rights Act, for example, yes, absolutely, Congress can change that. Now, whether there's political will in Congress to undo a Supreme Court ruling is another question, but you know, we often see an interesting dynamic between Supreme Court rulings and congressional action where they sort of play politically off each other and use each other for political purposes. And we may see that in some of the election and religious decisions that we've been talking about. Rebecca adds Little Sisters of the Poor. Exactly, that's exactly the same thing, yes, which was an even more fascinating case than Hobby Lobby. The guy with the cake baking business refusing to make a cake for the gay couple getting married. That's exactly what we're thinking about. Now that case, the Supreme Court ruled on, and the court decided a couple of terms ago that the Colorado Civil Rights Commission actually discriminated against the cake baker's religion because some of the members of the commission made disparaging comments about his religious beliefs. And so the court ruled that what the Colorado Civil Rights Commission was doing in that case was intentionally discriminating by religion. So the court went in a slightly different direction in that case. But if we were to take the same case and excise or rule out the statements by members of the Colorado Civil Rights Commission that sounded like they were targeting religion, then you just have a neutral law, right? You can't discriminate by sexual orientation. A neutral law that's running up against an employer's religious practice, and the court's got to sort that question out. We don't have a case on the docket yet. The closest thing that we have is the City of Philadelphia case, but I think the next case down the pike is going to be a case like the cake baker case. These are really great comments, very thoughtful and insightful. I totally appreciate it.
Steve, I think that your dinner is probably ready. I don't want to keep you forever, so just...
Oh, Barb, you know, I can't think about dinner when I'm thinking about constitutional law. Are you kidding?
I think what we're going to do is just have you back more frequently as people have more questions. So you and I will have to get together to see a date on your calendar. But I want to thank you so much for being with us tonight. And I know we all have appreciated your giving us your time and looking into those specific subjects that are all dear to our hearts. I'm going to turn the meeting over to Judy now, our president.
So again, thank you, Professor Schwinn. You always make us smarter. So thank you so much. And please remember this program was recorded and will be posted on the Wheaton League of Women Voters website. And then please join us next month, Thursday, June 10 at 7 p.m. It's about the Electoral College and is it time for it to be abolished by Rosemary Heilman. So thank you so much, everyone, for participating tonight. We always enjoy seeing Professor Schwinn. So thanks so much.
Thank you.
Good
Thank
night,
you.
Steve. Thank you.
It's a
so
true
much.
honor. Thank you, Barb.
Thank you, Barb, for doing this.
Thank you.